wouldn't like, which is you figure it out within 30 days, you disclose and you dispose of the interest. That's, I find, not very helpful, but it's there. The third is the one that most people would rely on, which is, well, you didn't have any official responsibility for the bond. This is the third bullet point on page 6. And you filed a disclosure statement with the State Ethics Commission, making full disclosure, and that should be fine. And then there's the fourth bullet point there, which is you filed and the government gave you an exemption. And that doesn't happen that often, but I worked on my funds. And so I did include, actually, as an attachment in here, the form of disclosure and the governor's exemption. As a practical matter, that's not done very often. And when a request for a governor's exemption is put in, governor's council spends a lot of time reviewing it, so wouldn't rely on it. Okay, appearance of conflict. So going back to page 4, this is item F. So this is one where the rules are really, really unclear. And I can tell you bullet point 1 here is accepting employment involving compensation of substantial value where the responsibilities are not compatible, inherently incompatible with your service with the school. One of the examples the State Ethics Commission has given is, if you work on the state police, you have to be very careful about where you might work outside of that and what kind of security services you might provide. And maybe that's going to be inherently incompatible because there will be an appearance that you're being the policeman for a private person. For most of you, I think there's not really an issue here. I'm just curious, when you became, when you joined the school board, did you have discussions at DESC about that, or?
I actually called the State Ethics Commission right off, and they gave me a ruling on the whole situation, and offered guidance on that. And I did talk to legal counsel for the department as well, just to make sure they were aware of this.
And those are steps that you would have to take. There's just no clear boundary. When is employment inherently incompatible? One of the times is when you are asked to serve in another state capacity. Interestingly, service in a municipal capacity would be okay. It's not considered inherently incompatible to be both a special state employee and a municipal employee. Yeah. Oh.
That's interesting.
It is interesting, isn't it?
Because it's a different authority.
Yeah. It's the different thought process. I don't know. I don't have a good explanation. I mean, there may be circumstances where, because this is such a vaguely worded statute, where it might be considered inherently incompatible based on the nature of what you're doing, but the mere fact that you're a government employee for a different kind of government, that's not problematic. The second bullet point is one of those where it seems obvious, again, attempting to use your official position to obtain unwarranted privileges. That's even in the nature of the prohibition, unwarranted. That should seem obvious. The third bullet point here is acting in a manner that creates the appearance that another person can improperly influence you. So this one actually comes up a lot. It comes up when you haven't exactly crossed the line, let's say, of gifts. It's hard to argue, let's say, aggregation of gifts in your circumstance, but it looks like someone might be able to influence you. So that is considered a prohibition of the state ethics statute. However, there's no violation if you've disclosed it in writing to the appointing authority the facts that would create the appearance of conflict. So this is one of those places where travel expenses sometimes are thrown in. Somebody provides travel expenses for you to attend a seminar, worthwhile. So here would be a good idea to make a disclosure of the fact that you've received those funds. The last key element in the state ethics statute is use of confidential information. It should be very obvious that you cannot use any confidential information that you've obtained by virtue of your service as trustee. I know you do most of your meetings as open meetings, but in fact you go into executive session from time to time, or you will over time, and you will be privy to confidential information, and you may not share that or profit from that in any way. What some organizations do, some state entities do, is they designate one person, either the chair of the board, an executive director, or somebody else, as like the keeper of the confidential information, with that person having authority to disclose confidential, make the decision to disclose the confidential information at such time as it's no longer confidential. It's one way to handle it. What else? Okay. That's it for the different areas of the state ethics statute. Then we have the disclosure requirements. So we talked about the annual disclosure. What we haven't talked about is the mandatory education. Have you done that?
Is that this?
Not really. It could be. But the problem with the mandatory education is that there's a very precise curriculum that the state asks you to follow, which is for everybody. It's for municipal employees, and accounting employees, and state employees, and special state employees. So we could have done a training tonight that only focused on that and getting those answers right, but it would have left out things that are particular to schools and charter schools. So I didn't, the URL for the mandatory online education is extraordinarily long, so I didn't write it down. And it's full of like nonsense characters. But if you go to the State Ethics Commission website and look, they have a couple of categories of things. Look under education, which is I think on the right side. It's very clear. It says mandatory education. Click on that. It takes about 20 minutes. If you get a wrong answer, it will make you go back until you get the right answer. So it is a combination of training and test at the same time. You're supposed to do it once a year. Excuse me, it's once every 2 years. Yes, once every 2 years. And you should provide a certificate of completion to your state employer. So somebody who's keeps track of board matters should hold out to your certificate of completion. You will find that some of the questions are a little complicated. I found that one of them, at least I thought the facts were a little bit unclear for the facts, the connection between the facts and the question. And some of them will, like I said, pertain to municipal employees and not really be of interest, but you will learn something from it. So this is something each of you should do.
The certificate of completion should be submitted to?
It's supposed to be submitted to your employer, which in this case is the board. I think it doesn't say appointing official. I think it says employer.
Do the board members submit it to the board?
So the board should hold on to it. Whoever it is who's the keeper of records for the board should hold on to it.
We'll start it by here.
Yeah. Okay.
So that's something that we should keep track of. Now, I did it because I'm considered a special state employee because I do work for charter schools. Even though I get paid, it's fewer than the threshold number of hours per year, so that makes me a special state employee as well. What we didn't do, we just went through all the special state employee rules. Now I'm just going to go through a couple of things. Yes. I'm so sorry.
I am so stupid and I hate being stupid.
No, you're not. It's really
I can't
technical.
imagine.
Yes.
You've got to give me an example of this bond thing. I
Okay.
want to, so that I don't buy a bond. I just don't get where that could be a trap for me, so
Well,
tell me.
okay, so if you hold mutual funds,
Okay.
right?
Or let's say I have a City of Gloucester bond. Is that the kind of thing that could be?
Well, that's municipal. So
Okay.
the answer is no.
Oh, municipal, right, no, okay. State of
But
Mass bond.
state, yeah, a
Okay.
Massachusetts bond.
Which we
Yeah.
have, so.
Oh, so
Okay.
that's an interest in a state contract. You now hold an interest in a state contract, and you have to disclose that.
Yeah.
Yeah. And get, basically permission. It's not a big
Sure, I
deal.
better be sure we have math.
It's not, it's, and here's mostly why it's not a big deal. They want you to own that bond.
Yes, they do.
But wait, tell me why that's a
They're not gonna
conflict.
squeeze this
Not,
out.
don't tell me that it's a conflict.
Oh.
Why is it a conflict? I mean, what is it that I'm falling interested, that I can be influenced by?
Yeah, so I can't really answer that. I can tell you it's because the statute is broadly worded. And what
Okay.
the statute's really interested in my personal view, is if you owned a construction company, and the construction company contracted with the state to build highways,
Yeah,
so then they're interested in that.
okay.
They're not really that
Okay.
interested in your ownership of the bond, but you can't exclude it from the language of the statute at this time.
All right. So just know the answer, don't know why it's the answer, is the answer.
In some,
Okay.
under the state ethics statute, that does come up a little.
All right.
Yeah.
Or it's not gonna cause.
I didn't quite get it, but
Start.
I don't think we have those math bonds.
Start worrying.
Yeah.
What? No.
We have City of Gloucester bonds, that's why I was worried. But
Yeah.
don't ask me why do we have those. That's why I'm worried.
The disclosure forms, sometimes they're quite lengthy, for certain people. And it's okay, you just disclose. That's what it comes down to. They want to make sure you disclose, And in your case, as charter school board members, your disclosure goes to extra places, but that's...
Well, in my case, at the last meeting, I was this close to.
So if you disclose,
Yeah.
is the burden then on the agency that you disclose to?
Yeah. I mean, and it's not clear that, I don't know what burden they're taking, it's just a disclosure
Well,
form.
whether or not they're gonna do anything about it.
Yeah, and
Or
they-
whether you disclose anything that they wanna take action about.
Right, so I guess that's
In other words, is your obligation done when you've disclosed?
Yes, it's absolutely done, and I don't think it really opens the door to a review directly. It's certainly not in the bond situation. I guess in other situations, they'd look at it and say, well, did you actually participate in the matter? Obviously not in the bond situation.
And it's a contract, but it's
They do consider it
a contract because it's a contract, but no one thinks of that as a state contract per se,
Okay, so I'll tell you where
for purposes of conflict.
it can be.
No, I
that's-
don't mean by this statute.
No,
yes.
even by this statute, I'll tell you a situation where it can be an actual conflict that involves or implicates other provisions of the state ethics statute. If you are employed by a state entity that issues bonds.
Right.
That's when it's a contract where we're not only looking at this provision now, we're thinking about the other ones as
Right.
well.
But you would have precluded it the way
Yeah, you would have had to do it.
Dave did if it, as a member of another state entity, disclosing it before anything else happened.
Right, if it's another state entity and you disclose it, then you're totally fine,
Right.
yes. Yeah, there are certain,
For a municipal bond,
yeah, you wouldn't have to put down.
now you feel better about it. So when we get to that,
Yeah, except that I own Gloucester bonds, that's why I feel good about that.
I see. So better to own Gloucester bonds than that. No, it's really totally fine as long as you disclose. All right, so a couple of differences with the employee. All right, so one thing I should make clear is we produce this code of conduct for employees. This is employee, meaning not so much their employment status for payment of wages purposes, but under the state ethics statute. And you can be an employee for those purposes. If you're part-time, full-time, if you are a regular employee or an independent contractor. So it's a different notion than you usually use. However, if you worked for fewer than 800 hours during a one-year period, then you are a special state employee. So you're more like a trustee in that situation. I don't know